Welcome, everybody. I'm Heather O'Connor from O'Connor Family Law, and today we have Adam Waitkevich. He is the founder and president of Divorce Financial Solutions, which is based in Worcester, Massachusetts, as well as the managing financial advisor for Concord Wealth Partners in the greater Boston area. Adam, thank you so much for joining us today. What got you into your current position?
Sure. Well, thanks for having me. So I've been a certified financial planner since 2004. So that was my first, step into finances. About 3 or 4 years into that, we came across different designations. So just by chance, I came across this certified divorce financial analyst designation. And at the time, it wasn't anything that I thought would be a long-term venture. But the content was interesting and it seemed to serve a specific market, people going through divorce. That was around 2008, 2009. So it took me about 9 months for the credentials. And I really started just making some calls to local family law attorneys. And really the response was unanimous. They definitely needed some financial collaboration in the divorce process. And so I really just kind of started locally, right in Worcester, met new attorneys each year. I hired my son, Joe, a year and a half ago, just to help with the workload. So it's been a really good experience. Our work's been well received in the community. And I think we're doing a good job. We're collaborating with good attorneys and people that are going through divorce to try to help them make better financial decisions, land on more solid footing post-divorce, and helping as we can in that arena. So that was the start. It's been going good since.
Yeah, and I know, so our firm uses you quite a bit, just whenever we have questions specifically about pensions or retirement accounts, but you do so much more than that with looking at a person's financial situation and really helping them kind of come out of the divorce process, because there's so much change that goes on through that.
Yes.
And you basically do what we do for them with moving them forward, but specifically with their finances.
Yeah, that's a good description. And it's a good partnership. So we're not attorneys, we're not family law trained. We work in a partnership where I think the skill set's complementary, right? So your expertise is in family law. And so you definitely have to help a client navigate those required decisions, right? An equitable division of the estate, child parenting plan, and all these other moving parts. So we try to help out with anything financial. Service-wise, you're right. We can do some specific sort of services, preparing a domestic relation order, something we'll talk about maybe later, or a pension valuation. The big takeaway I would have here is that most people don't enter a separation thinking about financial planning at all, right? So it's a lot of emotion-based decisions around basically disrupting what might have been a financial plan for two people with a shared goal. Even though they're looking at it different in the divorce, it's actually, a dismantling of that financial plan into sort of an unknown. So most people go through the divorce and look at their pieces afterwards and then try to clean it up. And if we can help, a better approach would be to look at it during the divorce, be thoughtful of where they might land. And that's where we come in through analysis and sort of some forecasting tools that we have to help them, make better decisions and optimize the separation agreement terms. That's the ideal situation. Divorce should be looked at like a financial planning sort of exercise. It's really hard to get people to focus on that. Again, certain divorces are not amicable and it's just not easy to think about that. But so that's what we try to do. And we have a really unique background in that we have specific divorce related credentials. And we also have certified financial planning, sort of more traditional financial planning credentials. So there's an overlap in that process. The skill set that we have just by our careers really lend to sort of helping a client with the many questions they might have, with a divorce separation.
Yeah. And what we've found oftentimes, especially within a long-term marriage, but it can really be any sort of marriage, is one person takes the reign with finances. And then the other person, a lot of times just really doesn't even know what's going on or what they have or anything like that. So I think thinking about all those things and getting somebody like you on their team right away, you have your legal team, you should have your financial team. That's what's really going to set somebody up for success post-divorce, is having all the right pieces in play.
I agree. You said it perfectly. And so you're right. The dynamics of a given household might be that one person they just took over those duties. And it could be the husband or the wife, it doesn't really matter. Mm-hmm. It's that person who hadn't been as involved that feels really vulnerable in most divorces, even if it's amicable, just because they don't really know where everything is. They might not know passwords. They might not have paid bills. They might not have ever looked at tax returns. So there's a really strong feeling of, wow, am I going to be, leaving something on the table? And we can help level the playing field as long as there's good sharing of information. So, we have a lot of moving parts that are part of a long-term marriage, and we try to organize it in a way that's concise and easy to read, with different charts, 1 or 2 page charts that help people make better decisions through that process. But But you're right. That fear of that one person that doesn't have the level of financial savvy in the relationship could make a divorce last a lot longer than it needs to, right? They're very hesitant to accept any agreements because they're always having this feeling of doubt. So that's something that we know just by feedback from the clients we've worked with is a really helpful tool. And that's really just what we call asset division, looking at everything from pensions and Social Security to the more traditional assets like cash and banking accounts and whatnot. But yeah, so, if you look at sort of what we might help do is that's, equalize that financial savvy in the relationship.
Yep. So what I'm really hoping for this video is that people who are either representing themselves or even sometimes a newer attorney who's just starting out in family law, I'm hoping to pull some tips and tricks out of you that people can really use in real life, not only so that they understand things better, but that if they're an attorney, they can practice better. And I think you're the perfect person to do that. Like I said, our firm, I know we use you quite often. Usually within a divorce, a house and retirement accounts or pensions are going to be two of the biggest assets somebody's dividing. Not always, but in many, many cases.
That's
so what are some of the things right off the bat that a person who believes they're heading to a divorce or just found out because they just got served with a divorce, what is one or two things that they should do that will set them up better than if they don't do them?
Yeah, great question. So I think the first answer is, and we get phone calls like this a lot as well. People that are contemplating divorce want to sort of get financial head start. You want to have a good accounting. So here's, if we're speaking to the spouse that took care of the finances, that's not going to be a big concern, right? But if we're not, we're going to talk, this could be for anybody who might be contemplating divorce. Make sure you have a good accounting of things, what kind of assets are going to be split. The easy ones are going to be your cash and your checking. But then you want to start thinking about types of retirement. Did one person save more than the other? And then I start to guide them. Once you have an accounting of things, and as they'll have to report that to the court through the court forms anyway. So they're going to need to know how to access those statements and determine what's going to be, sort of on the table. But then I would have them start thinking about post-separation lifestyle, not in a super detailed way, sort of like, hey, how am I going to retire now or something like that? But are their kids involved, and will one be more likely to stay in the house? And common question we get is, let's say it's mom is going to stay in the house, and let's say the kids are 3 or 4 years from finishing high school, and so there's a good family reason for that to happen. And that answer depends on the rest of the financial picture, depending on what other assets are available. And so those are the questions you want to answer, because if it's a no, for example, if there's no possible way that one spouse could afford to sort of keep the marital home and stay there, that might not be optimal, but at least it gives them a chance to explore alternate paths. And those could be anything. Co-own it for some time. Obviously that would have some challenges, but at least you can rule it out, because nobody wants to fight for a home and find out way too late that they shouldn't have done it. They can't afford it. And now they're post-separation, they're really cash flow poor and they don't know what to do. So we help find those answers out early in the process where they can change. So I think that's sort of some tips from the individual side, the people going through the divorce. And I think lawyers, for the most part, I don't have a lot of tips there, but just kind of being in line with that same sort of process. Like, don't let a client take an unrealistic stance. If you have a hunch that it seems not doable, or even a question around like an asset, I think it's good to either let your client know, keep a realistic sort of mindset, or get expertise. We see a lot of that with our state. We just happen to have a lot of people that are part of the Massachusetts state retirement system, and that means you and all other family law attorneys are going to have to deal with how that gets divided. And that's a real complex asset, because if it's a traditional retirement account like 401k, that can be split easily and relatively soon after the divorce. That's a real concrete path, right? All right, here's some money and I know I'll get half. But a pension it could be a lot of years past the divorce before it gets paid out. And a lot of people have questions about what that means in dollar values, and what that means with other pieces of the asset division. So I think realize what assets are out there as a lawyer, right? Is this a straightforward case where it's just 401k and house, no pension? That's going to have a more normal trajectory for sort of asset division. The moment you start seeing things like federal pension or military pension or a state pension, then all right, I might have some extra education for my client to make sure that they're getting the best outcome.
Yeah, and I've had people, and I want to speak specifically to pensions, because I think everything else is slightly easier to divide, but specifically with pensions, I've had people come in and they have their annual statement and they say, this is what it's worth, this is what I want. And I'm like, I think you're leaving a lot on the table if that's all you want. So can you speak to what what somebody should be looking at if their spouse or they have a pension. What are kind of the steps that need to be taken in regards to evaluation? How do you typically see that divided?
That's a good question. So let's be clear. We're talking about the Massachusetts state pension system, and that could mean, a state police officer, a court employee, someone who works at the Department of Corrections, someone who works as a teacher. So these are all sort of subgroups, MBTA, that they're underneath the big umbrella of the state retirement system. What's not helpful for people going through a divorce, but it's just a fact we deal with, is that everyone in the state who's part of that pension, they have to make weekly contributions, right? So it's almost, in a sense, it looks like a 401k, which is an elective deferral, but it's not, right? So this is mandatory. And those aggregate contributions get presented as a statement, and it looks just like a 401k statement. And so a lot of times in a divorce, someone might have 15 or 20 years inside the teacher's system, let's say. And so they've got a balance inside their annuity fund that says, 130,000. That is not the same as a 401k. In fact, really, you should dismiss that. It's not representative of the value. And what people want to know is that at that point, in my example, someone who has 20 years has a really nice vested pension. And so when that person retires, they're going to elect to receive a lifetime monthly pension. And when they do that, that aggregate total of all their contributions they made, that's retained by the state. And so what they do is the state uses that to sort of offset their costs. So the easiest way to explain it to people inside a divorce is that that statement isn't really a balance that you can access like a 401k. You can't split it, at least while they're working. And most people won't want to. It would be a poor decision, because once they do split it, they've chosen to take their money back and give up the pension, which is not a good financial decision at all. The pension's a much more valuable asset. So that's the first problem we see all the time. Even in a separation agreement, they'll reference the retirement account and they'll give it a value, and that's different. So that annuity savings fund isn't really value. It just represents the cumulative total. It's hard for someone to listen to someone like me say, that's out, throw it off the table. Because, if you're the other spouse, you're saying, what are you talking about? There's 130,000 or so in there. I don't get any of it. And they need to just realize that that's not part of the pension. That would be where you could value the pension, which is going to get the couple a more accurate present value that they can use. I don't know if you want me to go down that path yet, or do you?
I know you can just go down a rabbit hole, and there's so much to talk about when we talk about dividing, which I think is another really important reason that if you're an attorney out there and you don't have someone like Adam, that you can turn to, I think you're really doing a disfavor to your clients, because we focus on the area of law, but getting into the nitty-gritty of the numbers and the different retirement accounts and what's required, that's a whole other level that I don't think the majority of attorneys have. I don't want to say expertise, because we're not really allowed to use the word, but that knowledge base to just be able to do it without what I call kind of expert help.
Yeah, to me, there's nothing wrong with that. I would have the same answer for if as a planner, if I get a really complex tax question. Basic stuff, how much you can contribute to your 401k or something. But when it gets complex, you want to bring in an expert. There's no real service you're doing to your client by sort of either ignoring or pretending that you have expertise in it. And I think you're going to, as an attorney, you're going to have, you'll be a better advocate for your client, number one. And you're going to eliminate any chances of someone coming back after saying, hey, listen, this was a mess and we really missed, this part or that part, and I would have made different choices. So I would say, the time we get involved is really we're very specific. So our time doesn't really accrue into the many hours and hours, right? So we're coming in, we don't have to look at, the parenting plan, how the couple disagrees and all the stuff that you might have to listen to. We're really looking at an asset, and we know right away, okay, listen, if there's a pension, it's someone who has 20 years of service, this is a valuable asset. And so either they can choose to get it valued and line that value up with other assets on their balance sheet, home or other retirement accounts, and move through sort of the offsetting process, or they can just agree to divide it separately at such time when it becomes payable. And whatever path they choose, we'll give them the pros and the cons, right? From a planning standpoint, really quickly, the con for any pension is that you generally have to wait as the recipient spouse until the pension owning spouse retires. That might be fine. We're dealing with, I have a case now where it's the wife who has the pension and she's 55 and the husband's like 66. And so mathematically, if he waits for that pension, that's 10 more years for her. So he's going to be into his 70s. And so as long as he knows today that it's not likely for him to get his first dollar from this marital asset, he can either choose to say, hey, wait a second, I didn't know that, or I'm okay with it and I'll move forward. And so again, this is another quick example example of giving them that information now would allow for an alternate route. Say, all right, maybe you keep the pension and buy me out at some discounted rate or whatever they think is appropriate. So yeah, getting good information around sort of the dates, how, the length inside the pension, all of those things are going to really start to paint the picture of how valuable the asset is. And the last part would be preference, right? So sometimes you get a pension owner who just wants to keep the pension for all reasons. They don't want to give anything out. And that's okay if they can recognize that, just like a house, the person who's going to keep the house needs to pay half of the equity to the other spouse, so as long as there's money there to do it. But yeah, that is going to be, in this state, a really common asset and it works the same every case, but the dynamics change inside, right?
Okay. And so I think one of the things, law school doesn't actually teach you the practice of law. It does, especially family law. There's so many different intricacies to it.
Yeah.
And one of the things I think that is really hard for newer attorneys, if you're dealing with somebody who's doing this on their own, this might be confusing for them as well. But when you're dividing different things like IRAs, SEP IRAs, 401ks, pensions, there's different things that are mandatory. You can't just put in the separation agreement, we're going to divide this retirement account. Can you talk a little bit about the different types of accounts and what's required? It's kind of a multifaceted, so we can break it down. What should be in the separation agreement in regards to language? And then two, there's DROs, there's quadros, which I think a lot of people, I hear them say, oh, we have to do the QDRO. So it's a qualified domestic relations order. Can you speak a little bit to why the separation agreement isn't enough and you have to do extra work? Because on our end, we refer these out. We try to refer them to you because I think you just do such a thorough job. But a lot of attorneys don't do them. Again, it's a very specialized area. And I hear from people, well, why can't you just do it? So can you talk a little bit about why the extra step is necessary and why it's necessary in some accounts and not others?
Yes. So most of the question revolves around division of retirement accounts. So I'll start at the very beginning. So when you categorize accounts, and this is a good tip for everybody, when someone's taking an accounting of their assets, you can categorize them. So for sure, let's say cash in the bank or CDs, or I call those post-tax, right? So they're not retirement accounts. They're monies usually that are accessible. Those are super easy. You can split them even before you get divorced, right? If a couple has 50,000 in the bank, there's nothing saying that they can each take 25 now, and they don't have to get anything involved. When we get into retirement accounts and different types of retirement accounts, there is a legal requirement of a document. So let me be more specific. So when there is a 401k, 403b, private pensions, not public pensions, but like a private pension. So those are all retirement accounts that are governed by ERISA law. That's a federal law. And so just to give a quick background, not to go into the weeds, but by design, if I had a 401k, I can't give it to my spouse while I'm alive. It's not permissible. So it's an individual account. So think about an IRA. So an IRA is an individual retirement account that someone could open. It cannot legally be given to anybody else unless you die, in which case it would go to beneficiaries, or if you're divorced. So divorce is a life event that allows a transfer, but not without the legal document that you referenced. That is the function of a QDRO, which is a widely used acronym that sort of catches all documents like that, but it stands for Qualified Domestic Relations Order. That should be done by an expert. Joe and myself here at Divorce Financial Solutions, we are certified quadro specialists. And that just means we have credentials to help navigate that federal law. Because what you're doing is you're actually taking terms that are put into a separation agreement that's typically drafted by the lawyer. That's not enough. We couldn't send that into the plan. Let's say you have a plan with Fidelity. Fidelity will not accept that. They're going to want this domestic relation order that we prepare. So in an ideal and perfect setting, we're really just capturing the terms and the integrity of the separation agreement, putting it in the required form that Fidelity or the plan would need so that they can, properly record keep, for taxes too. So if you think about what's happening, let's use an example of a 401k with 200,000 in it. Well, if 100,000 is going to go to the former spouse, that's a transaction that needs to be mapped, put into an account with his or her social security number on it and things like that. So the quadro does all that stuff, but it does require usually best practice to have someone do it who's a specialist. I think a lot of lawyers, rightly so, just don't want to get involved. So if a client says to their lawyer, I don't want to deal with another person, another bill, can you help me? I think a good answer is that you'll probably reduce time and money and hassle. Because one of the things we do on our side is we navigate a lot of the stuff with the plan that the client will never have to deal with. But obviously someone going through a separation isn't thinking about that sort of thing. So really kind of to step back, only certain accounts need Quadro. So IRAs, Roth IRAs, like SEP IRAs, they do not. And so even though they're still tax deferred accounts, to just separate into two basic accounts, two basic types of accounts in divorce. You look at sort of all your pre-tax assets, and that's retirement. So an IRA or like a SEP IRA, a 401k. And then your post-tax are like the value of your house, your bank accounts, your checking accounts, and things like that, investment accounts. IRAs don't need Quadro because they're no longer governed by ERISA law. Now, sometimes, this is always changing. So some custodians of IRAs, even though legally they don't require Quadros, they don't even know. They ask for them. They still want them. So I want to be careful what I say. So by law, they're not required. But I can tell you we're preparing more and more what we, IRA Quadros, because these plans, they want that extra document to sort of cover their side of things. That's the only explanation. So normally you don't need it. And in that case, you kind of leave the couple to do it on their own. That's sometimes not a good thing, because when you wrap up a divorce, you hopefully have all the steps in line. There are definitely things to do. People need to update beneficiaries, change, sign off on quit claim deeds and transfer property. And so to leave one more thing to the couple to do on their own, like split IRAs, might not be the best, right? They might not execute on it for years. That's not good when you wait. Just to kind of wrap up, when you're dividing retirement accounts, if it's an ERISA governed plan, you need a QDRO, which is a domestic relation order. I would just say too, the state pension requires a similar document. Now, a lot of lawyers, and there's nothing wrong with this, Quadro is a loose term that's thrown out about anytime you need to split a retirement account. And it could be a military or a federal pension. And it's okay. It's not the perfect way to do it. But if a separation agreement says the parties are going to split wife's federal pension by Quadro, there's really no such thing in that arena as a Quadro, but the intended outcome is the same. It's really a court order. It's a different type of court order that we would prepare for that pension. And so we could still move forward. So I think it's okay for lawyers to just use the Quadro term. I think a lot of lawyers do it, but to be precise, you're right. The state pension is a DRO. There's no Q, and the reason is it's not a qualified plan under ERISA, and that state pensions are governed under state law, which is a separate set of rules than what governs private pensions like 401ks and things like that. But it's really, the terms don't really mean too much. The intention is that, listen, if it's a state pension, there's going to be a secondary document that's going to, divide it, and that's what the client needs to know. I think from setting expectations, and they appreciate that, saying, hey, look, the separation agreement says that husband will get half of wife's teacher pension, but you're not done here. To really get that accomplished, you need to prepare a domestic relation order or have one prepared. I'll stop there for now. With retirement accounts.
And I think that what you're saying brought up like 4 or 5 different questions. So I have to try to keep them in my mind. But I remember you were working with us on a case that I had where my client, who was the wife, her retirement was being divided. And one of the issues came down to how to elect survivors' rights. Right. I believe that was the issue. Thankfully, we had gotten in touch with you because the way you told us to do it was going to save her thousands and thousands of dollars. And it ended up being an issue that we brought in front of the judge. And the judge, was like, well, I'm not sure. So you're both going to have to bring in your expert. And thankfully, the other side sided with you and we were able to settle. Can you talk a little bit about when you're putting the language in prior to the separation agreement going in front of the judge? How important is picking your electives and getting that language correct versus if it's not in there, say an attorney comes in and they just says, okay, we're dividing it. What kind of mess does that make for you after the fact if it's not in the separation agreement?
Yeah, it's a great example. And it's really specific to not so much private pensions, but definitely public pensions. So sticking with the state or even federal pensions. What you need to account for is, there's usually not any disagreement. When the lawyers write up, or even when both sides agree, one spouse is going to get 50% of this pension. I mean, that's unilateral, right? So, all right, everyone agrees on that. It's fair and equitable. But what I think a lot of people miss the mark is that requires okay, now great. So we've got the basic terms, 50% marital portion. What happens is if the rest of that decision tree isn't decided during the separation agreement process and recorded within the agreement, you risk missing out on a lot of stuff that the parties should have been thinking about when they made the decision during the divorce, and you stick it on them after. And now you have all these questions, and I'll be more specific. So if you think about the timeline of a pension, and let's use a quick brief case study. So let's say the couple is, they're both early 50s, 53. And so there's a pension, but it won't be received until age 65. So you've got a 12-year gap before this pension is going to be paid out. Even though today at age 53, they both agree that half of that, the marital portion will be paid to the other spouse. That's step one. Step two is, what would they like to happen, or the courts, or, everyone who's making a decision, if either one of them dies between the time of divorce and before that's handled? There's a number of choices. On the side of the recipient spouse, unfortunately, there's only one choice. It just reverts back, just because that's how the state pension works. So that's the easy one, because there's no other option. But now you have a couple of different survivorship options that have to be or should be made within the agreement. That's either a lump sum death benefit or like a one spousal survivor benefit. Either of those are options. It's much better for us if it's spelled out in the agreement, and then we don't have to ask or make any assumptions. And as a quadro preparer, we really can't insert our opinion. We don't do that. In fact, we would always kick it back. What's happening as an attorney, if you don't answer it, is you risk the clients coming back to you later on anyways, usually not happy, right? So, hey, they've signed, they've paid, and they have unanswered questions. But then an additional decision is made. I always say there's two periods of time. Back to our sort of case study, someone age 53, there's a time where there could be one person predeceasing the other between 53 and 65. And let's say they make it to 65, you have a secondary set of choices. When the member elects to retire within the state, there's three options, and each option has some differentiation with type of death benefit available. And so it's better to talk about how they might want that person to choose it, right? So will they be required at retirement to name their former spouse, now, 12 years divorced, as their beneficiary? And if so, how much? Then you get into sort of specifics. What if either one of them remarries? And so there's all these sort of conditions that it's really helpful to know what the outcome would be. Unfortunately, there's not free reign. You have to work within a pretty rigid state pension system. It would be great if it was super flexible and everybody could customize, but they have to work within the state pension system and the rules. When we can, if we could get in, educate during the process, now you have the opportunity to think through, we've been married, 20 years, we should have a pretty substantial survivorship benefit versus, it's a short-term marriage. We might have, some good grounds to have a smaller death benefit. The conditions can be negotiated in the process, but to me, that's a more thoughtful way to do it. Without that information, you do get a lot of agreements that say husband will get half of wife's retirement pension, right? And that's that. And so from there, we're saying, all right, great. Half as defined when, right? So defined as time they got divorced, the point of retirement, and then we can go down sort of that whole marital fraction, right? So coverture is a frequently used term in divorce, and it kind of means the asset that grew, or the amount of the asset that accrued during the marriage. And that makes good sense logically, but you need to explain it well in an agreement. These are all good examples of how the pension can be a minefield. The state pension is just a lot of questions. And fortunately, for good or bad, we happen to know it pretty well. And so we have this same circular discussion, a lot, and when we educate. And I think that's a little bit of what differentiates us. We want to help clients make better decisions. We're not going to dismiss their case because it doesn't have the information we need. We'll ask them to kind of go back and get it and tell them why. So that's the pension and its many moving parts.
Yeah. And I think I want to touch briefly just on, we do a lot of high conflict. Usually the parties don't trust each other. Sure. And because they don't trust each other, they don't trust each other's attorneys. So a lot of times when we get into dividing either retirements or pensions, and we suggest, hey, we need to decide on a company to do the quadro, or whatever is necessary to finalize the division, and we suggest you, or they suggest somebody, and then the parties just can't agree because they're like, well, you're suggesting them because they're going to favor you. Can you just speak to that? If a couple comes in for you to do a quadro, how does that work if one party suggested you? Does it mean that you're not neutral? Like how do you do your job?
Yeah, it's a great question. And so I think this just comes from sort of an ignorance of sort of the process, right? So the concern is rightly founded. I wouldn't fault anyone for thinking that way, right? So if I've got an attorney and just don't like my spouse, their attorney says this person. Of course, that's a very natural thought. Why would we use their person? As a quadro preparer, we are really a neutral, and here's why. When we get as a quadro preparer, and I'll say again, we are not attorneys, so it's not our business to go in and insert our opinion and think, oh, well, I know they wanted to split this 50-50, but I think they meant this or that on the survivorship. We do not do that. We cannot do that. And that's why we would revisit with the attorneys if there's a gap in sort of the information we need. So how this relates to that sort of concern about neutrality is, if you as an attorney have a well-written agreement, and that means you cover A to Z with a pension, what is to be done, it's going to make our job a little easier, number one. But all we can do, interpret that language into the actual domestic order that goes back to the state. We're simply translating the terms in the agreement into the format that the state wants to see. And so if it's written well and it's written thoroughly enough, you could give it to 5 or 6 different preparers, you should have the same outcome, right? So there shouldn't be a different monetary outcome at retirement if the agreement is well written. That's where I would say, yes, this is our expert, but it's because they're timely. They'll give us a call back if there's an issue or a concern and things like that. And I think that would be the reason to refer, not because, oh, we're going to get a nudge, we're going to get a benefit. Now, with that said, I want to be clear. During the process, there are different ways to write the language, and the manner in which that language is written can result in slightly different monetary calculations. So that's a little different, right? So that's more strategy. The first example is, listen, we're done with the divorce. We've written the terms. We just need to find an expert to prepare it. You could come to us or anybody else, pick someone out of a hat. It doesn't matter. There isn't really anything that person could do to manipulate the agreement language. During the process, there is a little bit of strategy. So that would involve, all right, so how should we define the marital portion? In other words, with this pension, which is it's a fluid income stream, so it's hard to value it except for a point in time, right? So a lot of people know that if they're at 20 years, but they're going to work 30, it's going to be worth a lot more in 30 years than it is now. And the growth of a pension asset does grow more exponentially at the end of that period. So thinking through that, and again, this is where financial planning comes into place. You'd want to know more about the participant, what their goals would be, what other assets are involved. But just to kind of button up that question, yes, there could be some strategy involved with an expert retained during the process, where you still might get pushback from the other side to say, hey, if you use Divorce Financial Solutions for the language and your strategy, we don't want to use them to draft it. And that's fine. You could sort of say we're conflicted out, but the same circumstance would apply. If we provided the language and they didn't counter it and they didn't challenge it and they accepted it when it got put in the agreement, all we're going to do is just put it into Quadro, and we wouldn't manipulate it from there. So, but we've been in cases where we know it's just easier for headaches, and we'll help strategy on one side and they'll put the language, but we're happy because we know that nobody who gets it is going to be able to change it. So we've already kind of created the language, and we've given it to them in detail. So a little bit of a long answer, but no, I mean, normally we weren't involved in the discussions. You should be able to give it to anybody.
Can you talk for a second about any type of pensions that cannot be divided within a divorce?
Some states have, not Massachusetts, so not in this state. So some states have some that are not, and there are other ways to do it in those cases, but most pensions can be divided, even in pay status. And that's another example. So, some of the examples we use now were someone working who hasn't yet retired, so the benefit is still growing or accruing. Those can be split, but they're going to be split at some future date. Now, sometimes we'll get a call from an attorney where we say, oh, well, husband's been retired. The pension's, he has a military pension and it's been paid, he's been collecting for 4 years. That can still be split with a domestic order or equivalent. It's a military court order in that case. But so that's a question we get a lot. So it doesn't matter what phase it is in, whether it's not yet being paid out or being paid out, they can both be divided by some sort of court order. Now, everyone has a little bit different format. So you have military, which has its own requirements and standards. You have federal pensions like that. Think about like post office workers and things like that, other forms of government jobs. You have railroad pensions, which are pretty unique, but they're out there. We get, a few of those a year. Then you have your state, your state pensions. And then you have private pensions. Private pensions are probably more client friendly. There's just a lot more flexibility in what you can do. And those are going away, but there are still a few out there, like, some of the bigger companies like National Grid around here, they have a private pension. And things like that. So, but they can all be divided.
Okay. And I know just for time wise, I'm trying to keep it where people will watch it, but can you just give us a quick rundown of, obviously you do Quadro, the financial stuff. Can you just give us a list of everything that you do that could help somebody, if they're watching this, in what areas you can specifically help them and how they can reach out to you?
Sure, I'd be happy to. So the easiest way to describe it, and I'll say this to new attorneys that ask us, if there's any moving part inside the divorce related to finances, we can help. So things we didn't cover that we can always do offline with anyone who has questions. There are many different types of benefits, stock options, restricted stock, things that are, we kind of call that the executive divorce. It's a whole suite of different sort of non-qualified plans, like an ESOP plan. So anything, even if we didn't discuss it today, we can address, and we can help the attorneys make better sense of it and sort of strategize. We can also do sort of those task specific. So if a pension needs to be valued, we do that. So we'll provide a valuation and sort of give the appropriate reports to anyone who needs it inside the separation. We can do domestic relation orders. Now that's usually a post-divorce thing, but a lot of times we'll consult with lawyers about language. So really the big things are asset division. Another thing we didn't talk about were budgets. So it doesn't happen as frequently, but in a lot of mediated cases, we will work with the couples to sort of look at their projected post-divorce income, and that's with consideration of child support, alimony, and things of that nature. And they can really map out sort of side by side what they're each going to sort of start with, who's going to pay who support, all their expenses. And that's a really nice outcome, because now they're sort of taking a peek at their post-divorce lifestyle. And there's nothing better for them to be able to see that, all right, great, we've got all these joint child expenses. I'm going to have my own house, you're going to have an apartment. We've got all these payments, our discretionary savings, and we're both going to end up with some money left over. It gives them that sort of peace of mind to just continue to move through the process. So that would be like a budget analysis. And then we also offer a transition into traditional planning, and that is post-divorce, even though thought goes into it during, where they come out, and now we help them with asset transfer. So if someone's going to get a lump sum payout from a 401k or a pension, or just is going to move away from their, a lot of times a couple will have a single planning firm, and for whatever reason, one of them just wants to just separate for what, they just don't feel comfortable. They want to kind of move on and start new. And so we have a full service financial planning firm. We can offer investment management. So we can really help them transition into sort of post-divorce planning. And that's really going to be helpful, especially if we've already worked with them. So we've already sort of kind of uncovered and looked at everything they're dealing with. They don't have to retell their story, and that the transition is natural here. We're just kind of going to help them either on an hourly basis, or they can become a full-fledged client of Concord Wealth, where we can basically set up their new plan for one. And so that's the scope. Anything from pre to post-divorce that has to do with finances, we can help.
And how would they reach you?
Okay, so we are on the website. Our website's pretty robust and helpful. It's divorcefinancialsolutions.net. We're physically in Kelly Square in Worcester. Great location. A lot of stuff is remote. We do a lot of Zoom. We do a lot of sort of stuff by email or phone. So they can call anytime. If we're around, we'll pick up. We have a contact us page on the website. A lot of people use that. They can also schedule a specific calendar time to talk about things and leave little notes. We get those quite a bit. Just quick notes about, hey, I'm thinking about, divorce. I've got a pension. Can I talk to you? And we do that a lot. And we think that's going to just help anyone, have a better start to the process. We give them that sort of rundown that we did today on the video. So website, phone call, and lastly, and thankfully, you guys do a great job. We're really appreciative of your firm and others that trust us and have continued to trust us over the years. We do get probably more of our business through lawyers, and those introductions are helpful, because there's really no pushback, right? So they say, all right, Heather, we trust you, don't lead us astray. And we don't take that lightly. If we look bad, you guys look bad. So, we try to stay on our game. So any of those methods, and thanks for asking.
Yeah. And I think one of the things, again, if you're a newer attorney watching this, reach out to them, because what I find is the questions that I have, sometimes I feel like I should know this stuff, but, just having somebody else who looks at it all the time, just go through and say, yes, you're doing it right. Or maybe you want to tweak this, and the way you communicate and the speed in what you communicate, because there's so many people you reach out to and you just never get a response. But I think your communication style, as well as efficiency, I think is something that really has connected, what we do at our firm with you. And I sing your praises, because I think you're great at what you do. And, I love our relationship with the connection, because it's so helpful to our clients. So if you're a newer attorney, feel free to reach out. I hate saying that, because then I feel like I'm not going to have the time.
Well, we
can't get too busy.
We don't. And so, I'll work weekends if I need to. And that's the other thing, we don't need to really kind of market here. But if you're in a pinch, or any lawyer's in a pinch, and sometimes it happens, they need they got a hearing coming up, I've taken dozens of calls, I'm in court, Adam, we're scratching out new things on the separation agreement. Not a problem. We like to do that. We want to set ourselves apart. We're not rigid. We want to be accessible. That's the reason why I hired Joe. He does a great job in sort of making sure we can provide that service. And the last thing is, I've been an expert witness a bunch of times. That's not we don't want to get to that point, but a lot of lawyers want to know that, hey, if we're in a really highly sort of contested divorce, could you testify? And so yes, we can. And so we should be able to help you from A to Z, and that's sort of our goal. And so I appreciate all that marketing.
All right, well, thank you so much, because I know this is one of those areas that people just look at and they just freeze. It's like, and it's so important to people because they've put so much time and effort, and their retirement and their pensions and their financial planning are all things that they 100% need to move forward. So thanks for taking the time. I appreciate it. I hope everybody who's watching it, has been able to learn something from it. And if you need help with family law, feel free to reach out to us, O'Connor Family Law. If you need anything with finances, feel free to reach out to Adam.
Thank you, Heather. All right.
So, thanks so much. Bye-bye.
Bye.